Hi, everyone. This is Curt and welcome to another edition of Fire Law Roundup for this one for August 1st of 2022. And Brad, we have some news. We finally broke 500 on our subscribers, so that's a big deal. And as I said, we're going to select one of our 500 first subscribers to get a free copy of my book. So we're going to do that right now. And let me see if I can get the spreadsheet that I created. I put all 500 names in a spreadsheet, and yeah, here we go. So you give me a number between 1 and 500, and we're gonna see us. Let me get it up. Okay, I got it up there. So go ahead, give me 1
well,
and 5.
My fire department number, to be completely random, is 371.
371. 371. 371 is Jason Flanagan. Okay, Jason Flanagan. So we're going to reach out to Jason and we're going to get him. All I have is his name. I don't have his contact info, so I'll go through YouTube to try to get that. But Jason Flanagan will be getting a copy of Legal Considerations for Fire and Emergency Services. So 4th edition. Woohoo!
Congratulations,
All right.
Jason.
All right, Brad, why don't you take us away? We got a busy, a lot of interesting cases this week, but
all good stuff to talk about. A lot of local stuff or local issues, but let's start in Tulsa.
Yeah.
Now, let me just start off again by saying, as we always do, that this is a complaint. These are allegations. We're not going to pass judgment. We'll make some comment, but we're not going to pass judgment. We're not saying this is true. But here, 2 female fire chiefs have sued, claiming gender discrimination. They are already had been chief officers of the Tulsa Fire Department. And they claim that they were passed over for promotion because of their gender and then retaliated against after they complained. Now, there's going to be one very, I don't want to say damning, but call it troublesome if you were a judge or jury, one troublesome fact, which we'll get to. But let me give you a little bit of background. So here, both of the plaintiffs, both of the women chiefs, female chiefs, chief officers, one of them served as chief of health and safety, and that's going to be important. So before making her first complaint about gender discrimination in 2020, one of the female chiefs was the administrative chief. And
Brad, let me just add, because I know a little bit about that particular position, and my recollection is that's a 4-bugle position. The administrative chief reports directly to the fire chief. And it may be a 3-bugle position, but it's either 3 or 4 bugle. And it's like directly below the fire chief. So in other words, she was sort of in the number 2 spot when she made the complaint. I don't know why she
2 females here, right? Both chiefs. Right.
But I'm not sure why the deputy chief of ops would be a promotion, but there's something unusual about that position. But at any rate.
And look, let's start with, when you start reading this and you're talking about gender discrimination, you're already dealing with 2 women who have reached a very high rank in the fire department, right? Which is going to weigh against them. I would imagine there's another factor that will weigh for them momentarily. So they claim that during their career, they were both subjected to numerous incidents of sexual harassment. And as we've seen so many times, we see a claim where they say their employer, the city, has been tolerating this harassment and has not been really doing anything, that their supervisors, which is interesting. They're saying the supervisors have been tolerating it. Well, there aren't too many supervisors above them at that chief's rank, which is why your comment on the number of bugles is important. So they were saying that in 2020, both of the female chiefs were the only eligible female firefighters to apply for the position of deputy chief of field operations. So I don't know whether this becomes a 3 to a 4 bugle, or you would think maybe it's 3 if they're applying for deputy chief, but who knows?
Yeah.
In any event, the Chief Lynn contends that she was subjected to pressure from her superiors, which again, can't be too many people above her, and other firefighters, presumably below her, to withdraw her name. And the reason for that is because if in Tulsa, if you went over 3 candidates for a position, you would have to have an outside evaluation, independent evaluation. And so the pressure was, hey, withdraw your name so we can avoid this and keep this internal. That could be a little self-serving. And if I was one of the, individuals, I probably would say, no, I want an outside evaluation too. So, one of the chiefs wasn't selected, and claims that a less qualified male candidate was selected and became the deputy chief of operations. Normally that would be the end of story, but it's not. So she held the position, same position, but she was then transferred from her position as administrative chief to chief of health and safety, which is allegedly
as a former safety chief, that is a demotion, because no, I'm just joking. Being a safety chief was it was very, very difficult. I found that very, very difficult. But at any rate, I'll shut.
They claim it's a demotion, right? Whether it is or isn't.
I would too. If I was in any other position, I would probably consider it to be a demotion. So
okay. So she, that's her claim. And then she says that her duties of the position were reduced, and that Chief Curt was excluded from some of the normal involvement that the position of chief in health and safety would be normally historically had. So then let me add the last facts, and we can kind of evaluate. And again, we haven't seen the side of the city at all, right? This is a very one-sided statement at this point, but they claim that 2 male candidates also applied for the position. That gave them 4, which would normally require an outside evaluation, but that there was not an outside evaluation. And I think what's going to hurt them is an obstacle for the city, is that 2 male candidates were selected. So you've got 4 candidates, 2 being female, 2 being male, 2 holding the higher ranks, allegedly making them more qualified. Now, again, we don't know anything about the males from this, but they selected 2 males. So that's a pretty tough road to hoe when you've got 4 candidates, 50-50, and not one of them was selected was female.
Well, you get the retaliation issue as well, because I believe it was Chief Hurt that when she got passed over the first time, she filed a complaint. Right. And then it was after the investigation had concluded that she really had no gripe, that was an internal complaint, that then she was transferred and then passed over for the second promotion. So there's a lot of moving parts in the allegations here.
And again, we don't know much of anything. You would have to imagine the city, knowing that they've got 2 male, 2 females, and knowing that they've taken some action, let's assume justified in their mind, to change the roles and positions and all that around, they must believe they have some really good, strong basis for doing this. And presumably what you'll see is bad performance, bad evaluations, right? It all kind of comes out now, and which could be further retaliation when they start saying that stuff. In any event, we don't know anything. That's what it is. And I think the really good point is, boy, when you're in this position and you're sitting down and you're talking to your attorney, hopefully one of the things your attorney is going to say is, we're going to get sued based on this, right? You better have a strong position. Anyway. So
well, one of the things that jumped out at me was the allegation that the male was lesser qualified. And that's always, unless there's some sort of an objective process to determine that, how do you determine who's more qualified, who's not?
Maybe rank, maybe not.
I'm in grade, but some people can be in a grade and they're just not performing. Right. So I don't know. That's a tough one. Now, if you have somebody with 28 years experience and then they promote someone with 6 years of experience, you can make the argument. But if you got somebody with 28 years and somebody else with 24 years,
right?
Who's got a master's in this and who's got a PhD in that, or this certificate, that certificate? How do you evaluate? So that's a tough one when you start getting into, and probably the intangible is whose personality is better suited for the position.
Yeah, that's a dangerous place to go, isn't it?
It certainly is. And nobody likes to talk. You certainly don't like to talk about that in litigation, because then it just opens Pandora's box. But I think realistically, personalities and fit for a position is one of those intangibles that often is used, but then can't be justified.
Right. And when you have a past retaliation complaint, it sounds like what they'd be saying if they went on that is, well, she couldn't get along because she complained about everything on basis of gender. So yeah,
right. It's tough. So
you got to believe they have good legal counsel, hopefully better than some of the other cities we've seen. And they must believe they had a fair and unbiased process, and we'll see how this works out.
Yep.
Inevitably, we'll be talking about it. Okay, this is really interesting. Let's go to Texas. And this is an interesting case. Very local, right? Very based on local law, but Texas, you got a ton of fire departments. So, this could happen. But I was, as we get into this, just to throw out my thought, I was almost thinking FLSA calculation of overtime. I know this is going to sound weird, but the way they calculate overtime would be the same way they calculate back pay. But let me get into this.
Yeah.
So here, very simple facts in some regards. We have a Texas firefighter who was suspended. The suspension was supposed to go on for 4 years. It was later.
Let me just, in Texas, I think we've mentioned this before. The euphemism is you're indefinitely suspended, which is a euphemism for you're terminated. So when they say somebody's been suspended, my assumption is, unless they tell you suspended for 30 days, they're on an indefinite suspension, which is a nice way, a polite way of saying
he ain't coming back.
Yeah, right. But he was suspended. He was out for over 4 years.
Yeah. And then they reduce it to 14 days, which I don't.
At the end of the 4 years, by the way, through some sort of a process, he ended up getting his job back. And then he just, so now you've got the back pay issue between the 14 days and the 4 years. They owe him some money in there. Right. So
what they claimed, and I read this case a number of times, read a decision a number of times. It was so interesting, but I think I can explain it in a couple of lines. So what happened was he goes and gets another job during this period and actually makes more over the total span of the time than he would have made.
Imagine that. Imagine that. Isn't that a message to the fire department? The guys can get fired, go out and make more money.
Yeah, probably in construction or something, but yeah.
Well, down there, who knows? The oil fields, who knows? But
right, true. Yeah. So he goes and gets another job, makes more money over the total of the time, and then says, but I want to be compensated what I would have made under a specific Texas statute. This is not under federal FLSA or anything. This is under a specific statute. And the judge looks at the statute and he first makes a policy call, which I totally agree with. He says, listen, he said, just because you make more than you would have had you stayed on the job, that doesn't mean you didn't work 3 jobs. It doesn't mean that you went a long period of time without any income and then happened to find it so you didn't struggle. Doesn't mean that you didn't work overtime. Doesn't mean that you took an embarrassing or harder position, right? He realized that everything's not equal. So he looks at the law. This is really the holding. Looks at the law and says, no, I believe it has to be by pay period. And you have to look at each separate pay period. And that is the right holding, because that's unfair to say to somebody, look, we wrongfully terminated you, but you worked so hard.
And you owe us money.
Yeah, you owe us, right? You should be lucky we fired you or suspended you. You would have made nothing here. Yeah. We're such a bad employer. We pay so poorly. Aren't you lucky? Yeah. Anyway, so that was the holding. I don't know what more we talk about.
No, I think it's a good. It's good to get into the details of it, And this is one of those where do you look at the whole 4 years and how much you made over the 4 years? And the court said yes, you do, but you also have to look at it week by week, and where there were certain weeks where he didn't make what he would have made had he stayed employed on the fire department. You've got to compensate him for the difference. If he normally gets 1,000 a week and maybe a particular week he only made 400, you owe him the 600. You owe him the difference, and you got to look at week by week over the 4 year period.
And to me, that was kind of reminiscent of the overtime calculation, right? If you're paid differential because you earn certain money more, in that week or whatever, you look at your overtime for that pay period. I don't know, maybe it's not the same.
And week by week, I think, is a better way to think of this one. You got to do it week by week.
Yeah. Okay. Want to move to Portland?
Sure. Oh, yeah. This is another firefighter lawyer, actually. I don't know if you picked that up.
I saw. I got a big explanation point near that. Yeah. And I thought the comment was so great as we get into the facts, which are very simple. Here's I think what the firefighter who's an attorney said at the end after he does this, like, boy, if they could do this to me, a white male who's an attorney, imagine what they do to somebody else. And I think he was just looking for vindication. He certainly got it. So here's what happens. The city of Portland in Oregon, they settled a suit. So there's no admission of right or wrong. All we have is allegations. And like $93,000 is probably more than attorney's fees would be that's a pretty hefty fee. So they settled for more than what you would say litigation costs necessarily. But here's what happened. He was out on a medical for something that happened during a day, but he gets returned by his doctor. And then he goes, I think, to an IME, independent medical exam. He gets cleared to work. And then they terminate him anyway for medical layoff. And they say you're medically terminated. And he, says, well, you can't do that to me, sues. He thinks there's a different reason for it. And they settled.
Yeah, I don't know if you looked at the complaint. He pretty much threw in everything but the kitchen sink into the complaint. It was 18 different claims. Yeah. So he went after him on a lot of different counts, and they just probably said, let's find a way out of this. So.
Right. And look, if you treat an attorney badly, what do you think they're going to do? Right.
Well, there was a gal, and I don't want to get into the details of it. She's an attorney just outside of Washington, D.C., and she got fired from she was, first of all, being discriminated against by a small volunteer fire company, and they kind of threw her out of the company. And she's an employment lawyer who specializes in sexual harassment cases. And I mean, I'm like, it's like some knucklehead going into a bar and picking a fight with a black belt, because he's been drinking too much. Like, what are you thinking?
Right.
But at any rate, that's
no, totally agree. But either people are well advised, not advised, or don't seek advice at all. Who knows? Okay, this one I find really, really interesting. We're going to Michigan, and this is probably not so uncommon. I think their statute's pretty unique. Maybe you'll probably know better. But so here we have, and the facts are so bad, or the allegations are so bad. But let's first talk about, as we do a lot, immunity, right? So many states have an immunity, and there's two phrases people should know about: absolute immunity and qualified immunity. Absolute immunity says you can't be sued for anything you do, and a lot of governments keep that protection. Although some governments waive it for certain reasons, and they say, okay, well, you can sue us, but we're not going to make it so easy. You have to meet a certain threshold. So before I get into the facts, let me talk about two different thresholds. The negligence standard says that if I had a duty to a patient in this case, and I breached that duty by some standard, that I could be liable, or my employer, the government, could be liable to the patient or patient's family. And the standard of negligence would say, I failed to act as an ordinary EMT would act. I didn't follow the basic protocol. I wasn't careful, right? Now, that's much easier to prove against somebody. So the government say, we're not going to make it that easy for you. A mere mess up, a mere screw up, we're not giving you the chance to sue us. But if you believe that the EMT in this case, or two EMTs in this case, were grossly negligent, then a state can waive, and a city can waive. All municipalities have this, usually set by state law, right? They can waive their absolute immunity and say, if you can establish gross negligence, then we'll allow you to proceed. Now, what is gross negligence? So again, the standard of care in most cases, if you run over a pedestrian with your private vehicle, is negligence. You failed to act like a reasonable, ordinary driver. That's a very low standard. Gross negligence is this: you failed to even attempt to act like in this case, careful EMT. So I always give you the example of, look, if I intubated and I auscultated, right, and I missed the tube and you're brain dead, forget the proximate cause issue, right? Was I negligent? Well, maybe I was negligent because I should have confirmed it with capnography or, something else. But that might be negligent. But gross negligence, did I at least attempt to be careful? Sure, I auscultated the lungs, right? So much harder standard to prove gross negligence, except maybe in this case. Now let's talk about the facts. So in this case, first of all, Michigan, the legal holding, and that's all there is at this point, the legal holding is, listen, we agree in Michigan that although the government has an absolute immunity for medical acts, there is a statute or a provision that allows our municipalities to be sued for acts of gross negligence in the provision of emergency medical care. That is what has been ruled on. Now let's talk about the facts. The facts are not good facts, which is what leads to good law in many cases, or, good facts for somebody lead to good law usually. So the facts here are that 2 EMTs go to a apparently large patient. The first part didn't bother me too much, but they stand the patient up, have him walk to the stretcher because they said he was too heavy to move. Now, I won't get into vasovagal and, orthostatics and all that, but standing people up may not be the best. In any event, it proved not to be the best approach, although I understand I've walked people to stretchers a million times, but they hadn't done an EKG, they hadn't done his blood pressure, right? But they must have presumably looked at him and said, okay, you can stand up and walk. And he did, but unfortunately, once he's on the stretcher, he goes unresponsive. En route in the hospital, and again, to the point, they did put him on the stretcher and they are going to a hospital. So remember, gross negligence. Did they even attempt to act diligently? At this point, you would say, yeah, probably did, right? They got him on a stretcher.
So I think it depends on how far he was walking too. I mean, it's one thing have somebody get up out of bed and walk over to a stretcher 5 feet. It's another thing to ask the person to walk down 3 flights of stairs and maybe all the way to the ambulance. But that's not clear from the.
Yeah, I didn't see those facts.
Yeah, no, it wasn't clear. It just said they walked into the stretcher, but how far was the stretcher?
Right. And I'm not sure it matters because once he's on the stretcher in the ambulance, he's unresponsive. The EKG shows he's in arrest. And according to the EKG, which is pretty sensitive, they performed absolutely no CPR whatsoever, which is very difficult to believe. But all we have is allegations at this point. There's a motion to dismiss the case based on immunity. The court says, sorry, right? And I have to tell you that what courts normally would do is they would go one step further here. If they wanted to get rid of this case, they would say, but even if true, the allegations do not arise to the level of gross negligence, case dismissed. That's not what happened here, right? The judge recognized you could be sued for gross negligence and we're going back for a trial. So great holding because it's not so unique to many states. This I think would be more common.
Oh, yeah. I think gross negligence is generally considered to be an exception to immunity, whether it's sovereign immunity, statutory immunity. It's generally considered to be an exception. And, one of the metaphors I use it in my book and I use it when I lecture too, is to Dante's Inferno. And we use it on criminal side too. But you think about the layers of hell, and in Dante's Inferno, as you go deeper and deeper into the layers of hell, your punishment gets worse and worse and worse. So if you think about the metaphor here, negligence would be near the surface before you get very, very deep down, okay? And then you get down a little bit further, you get into gross negligence. And then you go down a little bit further and you get into recklessness. Right. And recklessness, there's a lot of confusion between recklessness and gross negligence, but recklessness is consciously disregarding a known and substantial risk of harm, that you consciously are aware of the risk and you ignore it. And then the lowest level of hell is intentional acts where battery, defamation, those types of things where you do something purposefully to try to injure somebody. So
becoming a lawyer, all subjects,
that kind of stuff. Yeah. But I guess we're standing at the devil's gate there, assisting people through. So,
right. But I do think it's important for people to understand. We have this, once a month, I think we talk about the standards of liability. And I think it's important because a lot of times have clients calling up saying, oh, people don't want to volunteer because they're so nervous about getting sued. And I said, look, forget personal liability. There's almost usually never any personal liability short of intentional acts. I said, but even, all you have to do is try to act carefully. You don't have to have acted carefully. You don't have to have acted like a normal EMT, paramedic, firefighter, or whatever. You just have to have attempted to act. And that shouldn't be so hard. And if you can't even attempt to try to act correctly, then probably your municipality should lose the lawsuit. So, but again, we don't know anything about the facts here. We only know about the allegations. Just because this went to court, it only went to court on the legal question, not on the factual question. But I'm sure they've got the court's attention. That EKG strip is going to be pretty hard to overcome, unless there are no leads. But I have a hard time believing that too. Okay. Let's go to South Carolina.
My favorite case of the week.
Yeah. And here.
And I'm thinking of you, Chief.
I know. I'm trying to bite my tongue. But occasionally there are those fire chiefs who can't, just can't get along with the mayor. And in this case, we have allegations only. Although the allegations are published in a newspaper and on the media. So here, look, I'll make this simple. We have a fire chief who has been in office. A mayor gets elected. And prior to the mayor's election, this fire chief and the mayor never got along. So the mayor comes in, asks the guy to resign. And the chief says, I'm not going to resign. I've been here for, 40 years, it last 23 as fire chief. I'm not resigning just because I get a new mayor. So the mayor then allegedly he takes over the financial bookkeeping and starts really making very public allegations, allegedly, right? And starts making very public allegations that were in fact in the news, because you can watch them and see them and read them, but is accusing the fire chief of a number of things. So one, and I'll go through those in short, right? He said he's making false statements. Well, the claim is that the mayor made false statements which impeached the honesty, integrity, and reputation of the chief and exposed him to ridicule. But the allegations were basically that the chief refused to participate in a review of the financial reports, inappropriately used social media. That's a pretty tough one if he hasn't attended your social media class. We'll see how hard that is. He failed to document proper bookkeeping of financial records. I think that's really the biggest one. Breached security repeatedly and used funding without proper documentation. Basically, he's accusing them of mismanaging and stealing. And in a lot of states, as in this state, there's some, and this is law school 101 for people. There's liability. And in slander, there's something called slander per se, right? And libel per se. Slander is spoken, libel's written. But what it means per se is, if you accuse me of a crime, I don't have to show that I was harmed in any way. I don't need to prove actual harm. The fact that you accuse me of a crime, like misappropriating funds, that's enough. So if that is what the mayor accused him of, then the only real defense, right? There's two defenses. One doesn't apply so much, which is, well, it was my opinion, right? The opinion defense almost always works in defamation until you accuse somebody of committing a crime. And that's not an opinion any longer, especially when you're the person's boss, right? And you suspended them and you have to come up with a reason. That's not an opinion. That's your version of the facts. So the other one is the truth. And in law, we always say the truth is the ultimate defense. So here, what's going to happen is the mayor is going to have to come up with proof to substantiate his allegations. And if he can't, the mayor's employer is going to be in a whole lot of trouble. That's that's where we are. Let's see.
Yeah. Interesting case.
Super interesting case.
Yeah.
Is that all of it? Wow, we just
Yeah, that's
five
it.
of
We
them.
went through it fairly quickly, and I do want to alert our listeners, we are going to have a second vlog today. I'm not sure what we call it, a special edition, Fire Law special edition, but we've got an attorney, Kevin Fairley, who's going to join us. It's going to be 3:00 Eastern, so another 90 minutes or so. But Kevin alerted us to the fact that the HHS, Health and Human Services of the federal government, has been focusing more on fire department billing, medical billing. They kind of backed off during COVID, but now apparently he's noticed an uptick. And I know, Brad, you do a lot of work, a lot of your clients, this impacts a lot of your clients. I'm interested in it. None of my clients really have had these types of things arise, but I'm very interested to talk to Kevin, and we'll get a little bit more insight into the nature of the problem, because that's all he does is EMS billing and hospital EMS transfers types of cases.
Well, let me tell you, in New York State, which as of July 8th, just allowed the billing of patients by fire department ambulances. So I just released a 7-module YouTube series talking about the new laws and the problems with the laws. But one of the big sections is compliance. And the wide open eyes I got from people saying, well, wait a minute, as commissioners or chief, we can be personally, criminally, and civilly liable. And I'm like, yeah. And the only defense, let me just give a little short precursor if people aren't sure whether they want to watch or not. If you engage in ambulance billing and you consistently make what you believe is a mistake, then a jury is going to have to determine whether your error in how you build something, whether you coded it wrong or whatever the error was, whether that mistake you made over 6 months, a year, 5 years, whatever, was it a mistake or was intent? And a jury, 12 people who couldn't figure out how to get off jury duty are going to be the ones deciding that you spent their tax money, right? Or you charge patients inappropriately, and whether you should be liable for intentionally, inappropriately billing. So it becomes a very scary jury question, and a compliance program, which we'll talk about right at 3 tonight or today. A compliance program says, listen, we taught our employees to recognize fraud. We taught our employees to report fraud. We punish our employees if they don't report fraud. We reward them when they do report fraud. We audit our bills after they're submitted. We audit our billing company. If there was an intent to defraud anybody, we sure suck at it, right? Because we taught everyone to report us. So that's what a good compliance program does. And if you are a fire department or an ambulance service watching, and you bill for anything, but certainly Medicare, Medicaid bills, and you don't have a compliance program, you need to be watching this. This is a big deal. You can be criminally liable.
Yeah, I want to include the link to your video. So just after we end, just shoot me that, and I'll include it in the in the listing for this post, so folks can have it.
Perfect. I'll send it to you.
Very good.
All for today.
All right, that's it for today, and we'll see you. Hopefully, for those of you who join us, we'll see you at 3:00. Okay. Thank you. We'll see you next week.